Give me a break. What was Hunter Biden doing in the White House with Joe? Crackhead Joe in there, getting him to sign pardons for his whole family. Where were you guys upset crying about Dr. Jill sitting in the Oval Office desk or Air Force One's chair, acting as acting president? Unchecked authority of an unelected individual. They were running the country, and you guys just sat there and tried to take out Trump, Judge. Doge wins again, twice again, saying that the requests for the TROs, the requests by the liberal groups, in this case, the state of New Mexico, plus a bunch of other blue states like Arizona, Chris Mays, gag me. She, of course, joined in on this. They were trying to stop Elon, and we read through the hearing excerpts courtesy of Margot Cleveland. We read through the briefings, the complaint brought by the state, and now they lose. Judge Chutkan wrote this. She says, all right, listen, plaintiff, 14 states who came in through their attorneys general, most of them morons, have filed an emergency motion for a TRO. They said, our states are going to die because Elon. So based on the briefings, Judge Chutkan says, the states have not even carried their burden. Hello? They're not going to suffer imminent irreparable harm. Absent this order, they're going to be fine. And so therefore, their motion is denied by Chris Mays. On January 20th, Trump established the Department of Government Efficiency and a subsidiary organization called the U.S. Doge Temporary Service Organization, collectively called Doge here. Now, I want to point this out here. A federal judge is officially acknowledging the creation of Doge. So every time, as we'll look at, some lefty group submits a complaint and they call it right here. You see this a lot, even in articles. You see the journos who are still so sour about all this. They'll write so-called. This so-called Doge department, because they're so bitter and cranky, but they'll write that they're so-called, right? All right. Well, it's official. Judge Chutkan even agrees. Elon Musk directs the work of the Doge personnel, directs it, but is formally classified as a special government employee. Now, the states, all the blue states, brought this action for declaratory and injunctive relief. They wanted to stop Musk from doing things. They said, he's not a real boy. He should have been appointed under the U.S. Constitution. He has not been nominated or confirmed by the Senate as an officer of the United States, right? This is a very familiar argument to us here because Jack Smith, who was definitely not a real boy, was illegitimate, right? And they're saying, well, Elon Musk is kind of exercising the same power. But remember, Elon Musk is not a special counsel. He's not subpoenaing anybody. He's not prosecuting anything. He's not in charge, officially of like these agencies. He's just a liaison, as we'll find out. So it's different, right? So it's a different argument. So they're trying that. Like, oh, Trump won on that. So let's try that here. They say that Musk and Doge lack statutory authority for their actions, right? And Doge was created before it was called Doge by Obama. Now, plaintiffs, the states allege, they say, well, Musk exercises, they say, virtually unchecked power across the presidential branch, the executive branch, making decisions about expenditures, contracts, property, regs, and even the very existence of federal agencies. How can one man have so much power? They claim that in the last few weeks, Musk and Doge have gained access, right? They keep saying to sensitive data, which is evidence of their corruption, information systems that they've been rigging, and technological and financial infrastructure that they've set up for themselves across the federal government. We know. They say Trump and Elon have allegedly used this unfettered access and authority to terminate personnel, place entire agencies on temporary leave, transfer data to outside servers. This is what their allegations are, right? Allegedly. Taken over physical office spaces, kicked out USAID. We saw that happen. And terminate contracts valued in the hundreds of millions of dollars, hopefully billions. Now, defendants, Trump and Elon, concede that there is no apparent source of legal authority granting Musk or Doge the power to order personnel actions at federal agencies, but do not deny that defendants are taking such actions, right? So Trump is saying, we're doing all of this, and we're not even saying that Elon has direct power to do it. We're not even saying that at all. Saying on February 14th, the states moved for a TRO to try to stop 11 categories of conduct by Musk and Doge, right? It was like wild. They stop everything. You have to go to bed by 8 p.m., make sure your bed's made, brush your teeth, do all these things, call us in the morning to let us know you're starting your work. You're like, what? You guys run the government now? They can't fire anybody, hire anybody, make any decisions, even look at the spreadsheets is what you're so paranoid about? So that day they filed, right? The court held a hearing during which the states significantly narrowed the scope of their relief. They're like, oh yeah, I guess we can't really order him to bed at 8 o'clock. So maybe we'll revise that. So, okay, you can set your own bedtime, but we're still not going to allow you to do this. Now at the court's request, they then revised a proposed TRO, right? So the court is again like nudging them like, hey morons, I can't do this. So can you change this a little bit? Poking them, go change that, which asks the court to then, like third draft at this point, enjoin Musk and Doge, right? They say stop them. They want them to stop getting the data because the data shows the corruption and then they can inform the president or the agency heads about the corruption and they'll make decisions. So don't let let them see the spreadsheets. Don't let them look at the QuickBooks, okay? Don't let them in there. Office of OPM, Department of Education, Health and Human Services, Energy, Commerce, and other things, right? Don't let them inside the files. If they see what we were sending in our emails, we're all going down. Terminating or otherwise placing anyone on leave, right? And this was the scope of their original order. Like, look how broad this was. You can't do anything. You're done because a bunch of blue AGs are upset about it. So Judge Chutkan, remember her, she writes, look, they want us to basically stop everything. And they're claiming that there's going to be all of these damages. But look, a temporary restraining order is an extraordinary remedy that should only be granted when the party seeking relief, in this case, the blue states, carry their burden of persuasion. Now, a party seeking this must establish the four things that come up a bunch here that I should work on remembering. He is likely to succeed on the merits, okay? He is likely to suffer irreparable harm. He balances the equities and it's in the public interest. So those four things, and she's going to give us the analysis on all four of those. Now, she tells us the court's analysis is going to begin and end with irreparable harm. That's all we need to talk about because it's a threshold issue and a requirement in granting temporary injunctive relief. We got to get past that. The other three factors don't matter if this fourth one doesn't get met. So to show irreparable harm, the injury alleged must be both certain and great, right? She's citing this is what the rule is. Actual and not theoretical. It needs to be beyond remediation. Like there's nothing else we can do to fix this. And it needs to be so imminent that there is a clear and present need for this type of relief, right? Forcing Trump to do something. Basically, the judge taking over control of the executive branch. She says we just decided that in 2021. So the possibility, if it's just possible, that's not enough. A plaintiff must demonstrate, in this case, the states, this is Chutkan writing, a clear and present need for extraordinary equitable relief to prevent harm. Extraordinary need. If a party fails to make that showing, you have to deny it. Now, on the record, Judge Chutkan says, from what I've seen, the court cannot conclude that the states satisfy the high standard for irreparable injury, okay? We know that Chris Mays and the rest of them are all going to be crying about this. We're dying right now. No, you're not. Calm down. Even Judge Chutkan says it. Relax. Plaintiffs, they say the state's declarations are replete with assertions. They say if Musk does this, if they cancel, if they pause, if they significantly reduce, then we're going to suffer extreme financial and programmatic harm. And they wrote all this in their whiny declarations. They say here, Judge Chutkan says if right there. Oops. If the actions of Doge led by Elon cancel our contracts, Washington state won't be able to uphold its legal commitments to its residents. Well, maybe you shouldn't have made those stupid laws in place. How about that? Upon information and belief, another declaration, this one came from Sarita. She says, well, New Mexico is going to be injured. Upon information, it says, if labor's sensitive data is compromised, if it is, the state of New Mexico would be vulnerable to embezzlement, maybe, and cyber theft, and ransom attacks, and other financial crime, blah, blah, blah. Okay, stop your hystericism, okay? It's fairy tale time with Sarita. Take your stories and save them for your kids. If existing programs are canceled, another one. This one comes from Wayne, also from New Mexico. If these are canceled or federal workers administering these are terminated, well, New Mexico is not going to be able to receive reimbursements. Well, why are you giving out the money in the first place? Stop giving the money out. Where's it going? To illegals? Connecticut's Department of Social Services funding is also potentially, they got sneaky. Okay, so these three examples had if. Judge Chutkan did a control F. She's like, okay, if. She's like, wow, there's a lot of options there. She read through, good job, Judge, and they changed it to potentially. Very sneaky lawyering there. Jeffrey R. Beckham didn't want to make it so contingent. Smart. Busted. Okay, it's all hypothetical. So stop your crying about something that hasn't happened yet. The court is aware, says Chutkan, that Doge's unpredictable actions have resulted in considerable uncertainty and confusion for plaintiffs and many of their agencies and residents. And by the way, this doesn't hold so much anymore. Okay, it was confusing and there were times were uncertain, like during the first week. But we're in almost a month of this. So if you're still sitting there, like if you're in the IRS and you're out there and you're like, oh, just going to audit some more right-wing groups again. Maybe Pete Hegseth deserves a little audit here. Some IRS hack. And Doge comes bursting through the wall like the Kool-Aid guy. Don't be surprised, okay? It's been happening for a month now. So what are you so shocked about? Relax. Should have started your resume a while ago. When you know they're like the Grim Reaper in that meme, going from door to door to door. U.S. aid was first. Treasury's coming next. Social Security's on the line. We're coming everywhere. So don't be so surprised, all right? Spare us the theatrics. But the possibility that Trump and Elon may take actions is not enough, whiners. It is still still uncertain when and how the catalog of state programs that the states identify will suffer right now. And again, the next point is obviously, well, if they do make some changes, then can the states come back and file a claim? Yeah, right. And that would be more appropriate. Say, this has been the actual harm. These are the things that Elon has done that is causing irreparable injury specifically, and come file your claim when that happens, which is also going to be a joke of a claim because they're going to say he's got no authority to do this, and he does. Chutkan continues. She says, when litigants have identified specific individuals or programs, courts have appropriately tailored TROs, but that hasn't happened yet. For example, she's citing these other ones, and this was the other case that hasn't been reported yet from February 13th, right? This judge made him put up the trans website pages back online. Said, oh no, doctors are relying on this. They don't know where to cut, so they might cut off the wrong thing, so put that back online because these doctors are flying blind without their website. So that judge ordered the website back on. Here was another one, granting the blanket suspension of foreign aid. Another hack judge. That was Carl Nichols, I believe. Also in DC, saying Rubio's not in charge of the State Department anymore. Great. Now, conversely, when litigants have failed to show imminent harm, courts in this district have refused to issue TROs. Other cases, right? Mere access to personnel data who are not formally authorized to view it without more creates an irreparable injury. Denying that one because that was their argument. So they didn't get that successful. So now with all of that precedent set, Judge Chutkan tells us the states, with all of that being said, they come to me, this court, and they ask this court to take judicial notice of widespread media reports. Like I'm just supposed to read and believe whatever the Washington Post is reporting, saying that Doge has taken or will soon take certain actions like mass terminations. But these reports cannot substitute for what the law requires, which is a specific facts alleged in an affidavit or a complaint that clearly show the immediate and irreparable injury, loss, or damage that will result. Now, this court may take judicial notice of this, of news articles, like they exist, that's fine. But I'm glad that they exist, but I can't believe that they're true. I'm not going to accept them for the truth of the statements they're in. Like that's not a substitute for evidence because some journalist wrote about it. Put it in an affidavit and swear to it so I can haul that person in here and ask them questions. And even if the court could appropriately consider the news reports, because remember during the hearing, the guy was like waving the Washington Post around. It's like, yeah, look, they wrote about it. It's like, I don't care, your stupid magazine. Even if the court could appropriately consider that, along with Trump's vague representation that, yeah, we did terminate a number of people last week, that's not going to cure your deficiencies. So the states were saying, Your Honor, look, they're even admitting they're firing a bunch of people. And in the hearing, the judge was like, how many people have you fired? He's like, I don't know. You don't know? No. Shouldn't you know? No, it's not relevant to you or to this case at all. If we want to fire 1,000 people or 10,000 people, that's our prerogative. Constitutionally, we're allowed to do that. So take it up with someone else, unless you've got some basis why we can't do that. Many of these judges just been using this as an opportunity to opine from the bench about their fury with what Trump is doing. But that doesn't matter. They can be mad about that. The law is the law. Now, terminating thousands of employees may cause extreme harm to individual employees and potentially the institution writ large. Yeah, that's kind of the point, right? Not harm per se, but it is harmful to the country, right? It's not healthy for this behavior to continue. So we have to rein it in. But they say, but harm, they say it's harmful. It's like, not really. It might be specifically harmful to them, but the executive branch doesn't exist to serve the executive branch employees. It exists to serve the American people. So we have to make trade-offs. This is a positive trade-off, all said and done. But harm, says Judge Chutkan, harm that might befall unnamed third parties, like random people the state says we're going to be injured, does not satisfy the irreparable harm requirement. It has to be connected specifically to the parties before the court. And the states have not adequately linked Trump and Elon's actions to any imminent harm that the states have in particular. Now, that being said, Judge Chutkan says, states do raise a very colorable appointments clause claim with serious implications. And so this is where she's going to throw her little opinion in. Musk has not been nominated by the president, nor confirmed by the Senate, as constitutionally required for officers who exercise significant authority pursuant to the laws of the United States. Bypassing this safeguard of this constitutional scheme, they say, Musk has rapidly taken steps to fundamentally reshape the executive branch. He's like a consultant. The people who are in charge of those agencies are taking those decisions with the lawful power to do that. Even Trump concedes there is no apparent, quote, source of legal authority granting Doge the power. Source of legal authority granting Doge the power to what? She says, to take some of the actions challenged here. Thanks for substituting the most important part of the sentence with your own words, Judge. Thank you. Accepting plaintiff and the state's allegations is true. They say Trump and Elon's actions are thus precisely the executive abuses the appointments clause seeks to prevent. But even a strong merits argument cannot secure a TRO at this juncture. She says says, even if you're right, we'll deal with that later. It's not enough here because a TRO requires a very elevated showing of imminent harm. So plaintiffs, the states, she writes, right, this is her little final word, they legitimately call into question what appears to be the unchecked authority of an unelected individual. Like, give me a break. What was Hunter Biden doing in the White House with Joe? Crackhead Joe in there, getting him to sign pardons for his whole family. Where were you guys upset crying about Dr. Jill sitting in the Oval Office desk or Air Force One's chair, acting as acting president, right? Unchecked authority of an unelected individual. They were running the country, and you guys just sat there and tried to take out Trump, Judge. So give me a break. And an entity was not created by Congress and over which it has no oversight. Well, Obama. It was an Obama agency called the Digital Selective Service, something like that. It must be indisputable that this court acts within the bounds of its authority, and accordingly, it cannot issue a TRO, especially one as wide-ranging as the states want, would basically limit Elon from doing anything, and Doge from doing anything. And so the record does not meet that standard. Signed by Tanya Chutkan. Before that, though, she says, and so for the reasons explained, it is hereby ordered that the states, all the blue states, and their pathetic request for a TRO is denied. States lose. Sorry, Chris Mays, read it and weep. It is further ordered that the parties shall meet and confer about further proceedings. If the states intend to move for a preliminary injunction, the parties shall file a proposed briefing schedule, state their positions on consolidating these later down the line on February 19th, 2025. Signed by Judge Tanya Chutkan, the same judge who was a disaster for the country when she tried to race through Trump's January 6th case before the Supreme Court took it away from her. She was doing everything possible to try to get that on the books because she knew she could have gotten him convicted in there in DC because it's 93% Democrats.